Okay, good afternoon, and welcome to the panel on privacy, data protection, and Internet of Things that I have the pleasure to chair today. I'm Shara Monteleone, a policy analyst at the EPRS, the European Parliamentary Research Service of the European Parliament. And previously, I have been working for the University of Groningen in the Netherlands. The objective of this panel is to better understand and discuss, of course, the advantages and drawbacks of the Internet of Things, as it will be clarified soon by our speakers. We will address different issues. We will start with standardization issues. Secondly, we will look at the ethical aspect of the Internet of Things. This will be followed by discussion on artificial intelligence and the law. And finally, we will explore Internet of Things in the workplace and the related privacy issues, of course. But before that, I'm happy to give the floor first to Professor Ugo Pagallo, who is Professor of Legal Informatics at the University of Turin in Italy, and who will give an overview on the topic of Internet of Things, and will also moderate the discussion. So Ugo, the floor is yours.
Thank you, Shara, and welcome to everybody. And let's see. Okay, as you can see, this is the third workshop that we are organizing here at the CPDP. A couple of years ago, the topic was open data and big data and group privacy. Last year, we organized the first workshop in robotics and legal challenges in the field of data protection and privacy. This year, of course, we'll be talking about the Internet of Things and open to suggestions for a new exciting topic for next year. If it works, battery out. Okay.
It can be helpful.
Maybe the starting point is puzzling because, technically speaking, we cannot talk about an Internet of Things. That's going to be one of the main issues of our panel. Just to give you an idea, are we talking about the industrial Internet, a smarter planet, the Internet of everything, or a new alliance? More on this with the first contribution today. And of course, whatever the definition, as Shara mentioned it before, on the one hand, the Internet of Things looks very promising, but on the other, very challenging. But the fact that we are still mulling over all these issues may represent also an opportunity, since we don't have an Internet of Things. We still have the opportunity to consider what we really want with this new scenario. This is why, as usual, we invited some well-known speakers with different backgrounds in order to introduce what I hope then the debate. I think we're going to have first the presentations and then enough time to open a discussion on the main points of our panel. And just to introduce the panelists, back to Shara.
Thank you, Ugo. So I'm glad to introduce you now Patricia Martigne, who works in Orange as a standardization manager for Internet of Things platform and services. She has worked in the telecommunication sector for 20 years, including Nortel and France Telecom, and she will talk about standardization issues.
Yes, thank you, Shara. Thank you. So, good afternoon. So, I'm Patricia Martigne, working in Orange as IoT standardization manager. And today I will provide a basic presentation of some clauses discussed in standardization activities related to IoT. And this is more like a basic material to open discussions. So don't hesitate to ask questions after the presentations. That's the real goal. So to begin with, just quoting some issues raised by IoT in terms of privacy and data protection. We can see some new challenges raised by this IoT. So you can see already relatively technical picture here, but it's not too technical, I hope so. Where you can find here the illustration of all these Internet of Things devices that we have to handle in IoT system. Then you can have a gateway that is like a concentrator that is able to convert some existing connectivity technologies to IP world, for example, but also to be a first step of aggregating data. And then you have this IoT network, the core network, where you can find, for example, the service platform, where you have some applications, business applications here. Also, you may find some applications embedded in all these devices. And of course, other applications embedded in the middle part, so which is the gateway side. So this picture intends to show you the diversity, not only of devices that you have to manage, but also the different layers from connectivity layer up to the applicative layer through the service layer. So just to show you in terms of technical aspects, you have to manage security aspects at different levels of the architecture. So basically for the IoT, the new challenges come from different points. I listed here just few of them, but they are mainly explaining the new challenges. For example, we are facing distribution of intelligence with this IoT. And this is a new aspect because compared to traditional centralized architecture, for example, telecom networks, we had some centralization of data management. Now we are going really into the world of distributed intelligence, from the very basic device up to service platforms. So you have different levels of intelligence, and you have to leverage this proliferation of possibly weak devices. And also, IoT business is all around this value put in the data and what you can add in terms of business value by using data. And from this, you have to handle in a correct manner all these data that are exchanged. And sometimes you may want to share this data with other actors, so you have to trust these actors, etc. So this is all the issues raised by IoT business and IoT systems. This causes more breaches in privacy and data protection aspects. And so what we have today in today's internet age, it's that we are dealing with data acquired about our environment, and in order to help us adapt our behavior. So this is today's situation. And here we already face some indirect privacy threat. But in tomorrow's IoT age, it's even worse in terms of privacy impact, because it's all about data acquired about our behavior. So we are really speaking about this end user and its behavior, and these data are used to adapt our environment. So that means also that some possible breaches in privacy, in security. So sorry, I will mix a bit both of them, because today in standardization we began with security aspects, and now we are realizing that we need more than security and really treat privacy. So I may confuse a bit the words today, but up to you to correct me at the end. But still, that means that any breaches in this system may physically impact our environment. So the breaches in terms of security and in terms of privacy. And this is where we were quite keen of this European legislation about data protection and privacy that puts this focus on the protection of data, the needs for more data protection and meeting privacy aspects. And we began with this directive 95/46, and I think that probably legal speakers here will probably speak more about this. But we also have this proposal for regulation, general data protection regulation from the European Parliament and the Council. And we have this Commission implementing decision from last year, which requests for standards taking into account privacy and personal data protection. So this is where currently in IoT standardization we are trying to focus more, because up to now it was not the main focus, but we are beginning this period where it's taking so much importance. So briefly, in terms of what we have today, so today we mainly have, we had some security aspects and privacy aspects dealt at the connectivity level, and we have some standardization solutions where you can store, for example, some credentials safely, and this is the case of the SIM card, so the well-known non-SIM card, which is the most secure today for trusted environment implementation. So I won't go into details, but from traditional solutions, we evolved to M2M solution. So here it's not really IoT. M2M is more vertical, about vertical applications. So with well-known client connected to a well-known server, and so that was some siloed vertical applications, and here it was the very basic foundations for M2M standards that then are evolving to IoT standard. But at that time, the fact that it was a vertical silo made it like a bit easier to deal with. We could focus on one flow, one WAF flow, and here the focus was about access rights and the different granularities of access rights to access different levels of data depending on this application. But now we have multi-actors emerging with the IoT, and this requires thinking at a horizontal level. What we call horizontal level is opposed to the vertical silos, and this is where we are now with this 1M2M architecture. So for IoT, there are several different trends in standardization activities, TM Forum, GSMA, etc. So I chose not to list everything because it would have been a nightmare just after lunch, but my choice was put to present a few clues of this 1M2M standard, which is a horizontal architecture for IoT. So taking into account for the application delivery, so it provides, it specifies a middleware at an applicative layer to be able to run any kind of applications from the device to the service platform through gateways, for example, but taking into account the fact that you may handle this with multiple actors, multiple devices, multiple manufacturers, etc. So this is the 1M2M system, and here the 1M2M standard made the choice to already include security by design, because as it's a relatively new group of standardization, it was already well aware of this need for security by design. So at least for the release 1, which was published last year, it already includes some security aspects. And for example, the main aspect discussed in this release 1 is about end-to-end security and how to use trusted environment and how to leverage underlying connectivities, which are probably for some of them already a bit secured, but how to go ahead this point and to now to be prepared for release 2 to include this privacy by design. And this is where we are now. So it's ongoing because release 2 of 1M2M standard will be ready second half of this year. And so, for example, we were last week in San Diego to progress on this release 2. At least for in terms of security privacy features, we had very good progress on this privacy protection architecture using Privacy Policy Manager. And so the aim is really to take into account, to provide some tools to be able to take into account the user preferences, for example, and to allow him not to give access to all his data to any application. So this is the main goal of this Privacy Policy Manager, which is now defined in 1M2M draft release 2. But we have also some aspects about role-based access control, token-based authorization, dynamic authorization, etc. So I can enter into details of this part of 1M2M standard, but it will depend on your questions at the end. So just to briefly conclude this presentation, so we can see new challenges raised by IoT domain. We have this European legislation that is opening our eyes towards needs in terms of privacy aspects, and now in standardization activities, we are taking this very seriously into account, and this is, for example, the 1M2M standard consideration now for release 2. Thank you very much.
Okay, thank you very much, Patricia. I'm happy to give the floor now to Brent Mittelstadt. Brent is a postdoc research fellow at the Oxford Internet Institute, University of Oxford, and is currently working on ethics of learning algorithms as used in personal data analytics. And he will talk to us about ethical challenges of Internet of Things.
Right, well, thank you very much. Very happy to be here. This is my first time at CPDP, and I'm enjoying it quite a bit so far. So yeah, I'm from the Internet Institute at the University of Oxford. I do some work with Luciano Floridi, who you may know from the work he's done on the right to be forgotten, philosophy of information, and so forth. And what I'm going to talk about today is sort of some of the preparatory work that we've done for a project that we are about to start on the ethics of the Internet of Things. So some of these are sort of half-formed thoughts or landscaping work. But yeah, I hope that you find it interesting. So my background is in philosophy and ethics. So of course I have to define my terms before I talk about them. And also I think it's quite helpful when talking about the Internet of Things to specify exactly what technologies and sensors, devices you are talking about just because it can mean so many things, as was just highlighted in the previous talk. So I'm understanding the Internet of Things as essentially a network of devices and sensors. It can be bespoke sensing devices, things like wearable computing, or it can be what I would call dumb devices that are brought online that have networking capacities added to them, like for example, when a kettle suddenly gets the ability to connect to a Wi-Fi network. And what's interesting about the Internet of Things is that information flows very much go from device to device rather than just device to user or device to manufacturer or the other many types of information flows that we've seen in the past. So I identify, I suppose, two characteristics of the Internet of Things as I've defined it that will raise ethical challenges. And the first is that it has to do with what are the challenges of bringing devices and aspects of personal life online that were previously not online. And that would create a challenge, what I'm going to call the accountability gap. The second has to do with the sorts of data that IoT devices will generate. In particular, IoT devices that are what I would call personal IoT devices, where they are in some way tracking the behavior or the preferences of the user or the user group. And so that's going to give rise to a challenge called, that I like to call the privacy of the group. And so what I'm going to start out with is just a few examples that have sort of piqued my interest, I suppose, in terms of the ethical challenges of the Internet of Things, and will hopefully answer the question if you're wondering, why do we need ethics in this context anyway? So I've been wondering about what sort of responsibilities that IoT designers have. And if you're a reader of Ars Technica, or I think the Guardian covered this yesterday as well, you may be familiar with this picture already. This picture is one that was provided by the Shodan Images service. What Shodan is it basically a search engine for the Internet of Things. It scans the Internet for poorly secured devices and then provides the IP addresses or the access links to those devices, and people can attempt to infiltrate them if they so choose, but that is not necessarily the purpose of the search engine. And so it got some press recently because they offer a images service, and what that images service does is show pictures from unsecure webcams that people have managed to get access to. So there were quite a few very provocative pictures of sleeping babies, such as this one, just to sort of show you what are the consequences of a poorly secured IoT device. But of course, it's not going to just be consumer devices that we need to give attention to, and this is, again, a screen capture from that web service. And this is sort of their spotlight feature for the week or the month, I'm not quite sure what. But they're drawing attention to the fact that there are quite a few poorly secured industrial control systems. And again, they will provide links to those systems, and they provide you some information about what the systems are, potential ways to gain access to them, and so forth. So it's quite an interesting space that they're operating in. I mean, I will say they're doing this to draw attention to security flaws with the Internet of Things, but certainly raises some very challenging ethical questions. And I think what's interesting about a site like this is that it makes the barriers to entry to try to infiltrate one of these systems or to gain access to an IoT device quite low. And just two final examples that you, again, may also be familiar with. The bottom one is from a story published by Wired a few months ago, and that was about some security researchers in the US that managed to hack into a Jeep. And remotely, they could do things like disable the brakes on the Jeep while the person was driving. And the top one is a sort of homebrew IoT microwave that someone has designed by adding a Raspberry Pi device to their microwave. But it raises an interesting question with mundane things like a microwave, a toaster, a kettle. If they go online and you can get access to them, what sort of damage could you actually cause to the surrounding environment and the user if you chose to? And so I suppose the way that I see the state of the IoT now, or at least this small segment of the IoT that I'm talking about, is that there's certainly space, there's sort of a gap in regulation, a gap in accountability that allows for things to be designed very quickly, that allows for, I suppose, a race to the bottom. Not to say that this characterizes the whole IoT or IoT design firms, but rather just that race is allowed to continue. And what it does is result in devices that are poorly secured, where there's not proper sort of reflection and planning on, okay, what are the implications of actually adding networking features to this device that may have been previously or in the past very well regulated. I'm thinking of cars in this particular case. I think that, or at least I think that may be the case because it's very difficult to predict the consequences of bringing these types of devices online. It may initially appear that bringing something online, like a kettle online, is a very sort of insignificant change to the device's functionality. A smart kettle, its primary function is still, of course, to boil water. But what these devices do is create new points of entry for intrusion. And so they, of course, risk exposing personal information, whether it's passwords or just logs of behavior, performance logs, whatever sort of data is being captured by the device. Or, as I mentioned previously, it creates risks for the environment, for the user. For example, disabling the brakes on the car. And so that sort of problem has been, I've seen it very cynically described somewhere else as taking the insecure and sort of centralized internet that we have now, that we've inadvertently designed, and then introducing that to a whole new range of devices and aspects of life that so far have been safe from its reaches. I think, again, that is a bit overly negative and cynical, but it is sort of an interesting way to look at the problem. But I think so far it may come off that I'm blaming the regulators, or sorry, blaming the designers, the development firms for some of these problems, but of course some of the responsibility has to also lie within policymakers, people setting the regulation for the development of these sorts of devices. So what I would say is that there are sort of three elements for what I'm describing as the accountability gap. And that's going to be when the design of a device is done in an irresponsible way, which means that it's done very quickly without proper reflection on what the implications of bringing the device online could be. That we have these inherent security risks with the internet that already exist, and we're introducing them to new devices. And also the classic problem of regulation not being able to anticipate developments in technology and to respond to them in a very fluid and quick manner. So up to this point, I have mainly focused on security risks of IoT devices and how the attitude taken towards them from a regulatory or design perspective can be ethically problematic due to a lack of accountability. What I haven't done yet, though, is address the challenges of the data that is generated by the devices beyond talking about the potential for data leaks or hacking. I'll treat that as sort of a separate issue. So the second half of this, or I should say what I'll do in the last 5 minutes or so, will be to talk a bit about the implications of this data, the data generated by, again, what I'm calling personal IoT devices, where there's sort of a one-to-one relationship between the device and the user. And so what that segment of devices does is generate unprecedented amounts of data about the behaviors and the preferences of users. And as a result of that, you can start to blur the boundaries between, okay, what are ethical issues with the IoT and what are ethical issues with big data more generally, or at least personal big data. And I think it is worth just recapping very quickly that sort of some of the headline ethical challenges with big data have to do with the position of the individual or the capacity of the individual to actually understand what is happening when their personal data is being processed, and also what actions are being taken on the basis of it. And the barriers to sort of comprehension would have to do with the ubiquity of the data, the accessibility to data sets, to algorithms that are used to process them, and just the complexity of those processes as well. So just sort of keep those things in the back of your mind. So at the moment, European data protection legislation seeks to protect the privacy rights of identifiable individuals, and the identifiable bit is very, very important here. I think some of the difficulty that we're facing here has to do with this focus in data protection legislation on identifiable individuals and how the individual can control their data, control data about them. Because as data scales up both in complexity and volume, controlling it obviously becomes much more difficult. So I'm in the first instance imagining privacy here as something that the individual is empowered to protect. For example, by being able to request information from data processors about how their data is being used. And so I don't think that we really have the correct conceptual language to frame the privacy challenges that are going to be introduced by the IoT, and you can argue by big data more generally. The primary protections that we'll have for privacy within data protection legislation will have to do with consent and anonymization and limiting the purposes for which data can be processed, and they're very much focused on the individual. It's worth remembering, though, that again, this focus on the identifiable individual misses that ethical harms, sort of group level ethical harms, things like discrimination or preferential treatment, can occur even when a data set is perfectly anonymized. You don't actually need to know someone's identity to do something harmful to them or to do something good for them, not to just take a negative tone here. And you can legislate against some of the more egregious harms on a case-by-case basis, like we've done with personalized insurance premiums based on risk profiling. But it still seems like the focus on the individual is missing part of the problem. And this is still a problem with the forthcoming the data protection regulation as well. Within the data protection regulation, you still have this belief that if you protect the privacy of individuals, of identifiable individuals, then you are also protecting the privacy of groups automatically. And that's absolutely not the case. Just for the simple fact that all members of a group are going to be affected by actions against it, regardless of whether each individual member was identified in the run-up to the action. So in other words, things done to a group or a profile that you fit are still going to affect you, whether or not you were involved with the run-up to that. So what I'm talking about here is sort of profiling. It's identifying small patterns within data. And we need to consider how IoT devices contribute to that. So once you go beyond how an IoT device serves the individual needs of the user, something like providing feedback on a workout routine you just did, then the user is really only interesting to the manufacturer of the data processor in comparison to other users. So the user is going to be comprehended by the data that is generated about him or her. And that data is really only interesting in the company of data describing other similar users. So what I'm saying is the user is interesting only as an example of a broader phenomenon or as an example of a broader profile. And what I have here is this is taken from the draft data protection regulation. I realize now that this may actually be out of date. I believe this is based on the council's draft of it. But these are essentially rights that exist within that draft against profiling. And there are actually quite a few rights here that are, I think, going in the right direction. But again, all of these still address the individual, the identifiable individual. And some of them will give you, for example, the right to question automated decision-making or processing, but they're still not addressing the group. So just to conclude quickly, what I'm proposing is essentially a reconceptualization of the right to privacy away from the model where individuals need to retain control of their data and towards a model where the rights are protected at the group level. And I'm proposing this shift based on the observation that personal data is interesting insofar as it allows the individual to be located within a broader group or phenomenon. The language that we're currently using is very much based on the individual, and it doesn't reflect the fact that the way that big data analytics make sense of the individual are in placing that individual within a broader group. So therefore it would make more sense to pay attention to how the search for these small patterns within the data set can be controlled in some way, in parallel to what we already do to observe and manage how individual data is moved and controlled. So I'm not proposing this as a replacement for individual privacy in any way, but rather as a further dimension of privacy that we need to be paying attention to. And what we have here, the 4 points on the slide here are just initial ways that a theory of group privacy that work, or in other words, the types of controls that you could get if you start to think of privacy in the group sense. So you could prevent the construction of certain types of profiles, for example. But I realize I'm out of time now, so I will conclude there. Thank you.
Thank you, Brent. I will give the floor now to Erich Schweighofer, professor at the Center for Computers and Law at the University of Vienna. He's an international expert in the area of legal informatics, including privacy law, and he will talk about artificial intelligence and the law aspect of Internet of Things.
Thank you very much. Now we heard a lot about standardization and ethics. Now it's the question what law and technology can do. Just a few words about artificial intelligence and law. There are regular conferences on this topic for many years. It's lawyers and computer scientists dealing with these aspects of formalization of the law and related problems. And for us, Internet of Things, privacy is one of chance, saying we have a new possibility of moving on, finding a new application area as expert systems didn't work so well so far. For my talk, it's mostly what we can do with privacy-friendly data processing technology. Is it a move on? Is it something new in the regulation? Then I will deal with the well-known topics on privacy by design and by default, privacy impact assessment, and then in particular some new research also, legal risk analysis, a lot of risks mentioned in the regulation, and then somehow what it means for hardware and software development, how you can improve it, and then some conclusions. I mentioned to Rolf Weber, he's a data protection specialist in Zurich, and he's mentioned that the law is not quick enough, so we can establish principles of data protection, but it's not sufficiently strong and quick for day-to-day solutions. So we have to move to technology-oriented protection of privacy, and in this opinion that I share, it's the main development of the new regulation. So we're opening the way up to this kind of technology-friendly data processing technologies. It's some kind of a program in the regulation, and we'll see how it will develop, and I will present some ideas here. It has some advantages because you have no data protection violation, it's preventive, it's friendly, and for us, for our discipline, it would mean we can help in that, so we can develop this kind of technologies. As you've seen, this devices are not dumb anymore, they're quite intelligent, so they can do it and you can build in some privacy. First of the ideas is privacy by design and by default. It's the well-known idea of Anne Kavokian, and you find it in Article 23 of the General Data Protection Regulation in this compromise text. You see, for the principles, actually should be some kind of a working list for all data processing institutions, but still when you see from the principles, proactive, default setting, some kind of design of legitimate use of data, then we've heard about data security, that's a bit more developed because stronger concerns by the enterprises, and also trust and accountability, also a strong concern from ethics sides. When it comes to rules, what you really can do, it means mostly minimal use of data, so anonymization, no use of real personal data, or anonymization of data, and so on and so on. That's what's possible. Then from the privacy impact assessment, that's now only for very few cases that you should do that, but here you find the strong risk assessments of possible dangers to privacy. It's in this case, it's mostly automated data processing, as you mentioned also, profiling, they should do this. And risk is a very nice concept. Everybody has some idea about it, but what does it mean in the legal environment? I mean, yes, you have to consider it, make some assessment, then consider if you can minimize it, then also some compliance and procedures about that, also some accountability. In the very end, it would mean we have to develop some guidelines, some certification, develop some good practices. So far, it's a bit not so developed. And you will also see how data protection authorities are active. When you see concerning risk analysis, there's some research on that in the legal environment. You wouldn't believe that. Particularly Sweden, Norway, Austria, Peter Wahlgren, Tobias Mahler, Thomas Price, also myself. And that means also we use our expertise in formalization. Formalization means we went from text to rules, ontologies, to make the legal rules precise, clear. So we have a much better understanding what the rule really means. And present state of the art would be used some kind of visual formalization languages like SysML, ontologies. So you have a good rule set, and then you can collect some data, and then you can analyze the risks. So statistical data plays a strong role, but also not just real data, also some kind of generated data according to certain assessments, like Monte Carlo methodology will help. So some simulation techniques may be also helpful, and we can dig into the research from mathematics. And then you have some kind of risk review cycle, so you can a bit display where the risks are, how they will develop. So it's a bit on the start of there's some books on that, but still has to be further developed, but it can be quite helpful. And then when it comes to how to design systems, the question is always this kind of devices. Should it be really related to a person or not, the identification? You have also decided what you shall do. Shall you use full identification, that I know this is the refrigerator, or with the device of someone, or pseudonymization, or anonymization. And there's also some idea of federated identities, so we have some kind of group identities, like Walter Hötzler has worked on that can be quite useful, so you don't need the full picture. Then the communication issue, should we use really plain text or encrypted data transmission? That should be the standard. And then the data processing, the minimal use of private data. Then how much you should store there. And there you need intelligent solutions. Always in the picture that this device has to process some data. The question how much is communicated, how much is stored. And I have one short example before I will finish. But then, just for the design, you see that's the principle, what you should do. Anonymization as often as possible, encrypt data, you don't process, you don't store data, private data if not necessary. And what's also been helpful from artificial intelligence, you can have some agents, software agent there, and they may decide what kind of service may be appropriate or not. So also maybe some would like to have not so much concern about privacy, others more. So some agents could be supportive. Then the example is about smart video surveillance of elderly people with IP cameras. So you can see what you can do. You can encrypt data or not, so you should encrypt it. Then also some kind of smart surveillance that's also happening. It's quite strongly discussed. So deliberate blurring of activities as much as possible. So normally you want a very general picture. So the main picture that someone is living there, not much more, and not full picture. And only if you have a clear picture, if in certain situations, so communication situation, emergencies, predefined emergency situations with full picture. And to put this into the system is costly, but it's all important for the privacy at home also. And then also storage issues, so you can collect it, keep it for days, weeks, or you say maybe 1 hour is enough, otherwise I don't need it anymore. So it's, there are many options where you can design the system and accordingly to ethics and also to new legal rules. So from the conclusion, there is a chance for our discipline, artificial intelligence and law, and we can be supportive because we can do a lot of, let's say, this kind of principles, weak rules can be more clarified, put in some kind of what it really means for the stakeholders. You can use, there's a lot of done with visualization that's helpful, but more you can do with ontologies, also to try to program this kind of rules in a rule set. And SysML seems to be a good possibility because there's so much experience in other fields in technology. So we may use it for our discipline too. Then we had a panel already in the morning on risk as such. There's not so much methodology, so that has to be further developed. But then you can say that's some kind of supported development, and also then helpful for legal disputes, where you can assess if the firm enterprise has done what she should do or not. So there's a potential that to be further developed, and looking forward to that. Thank you.
Thank you, Erich. And now, last but not least, we have the pleasure now to listen to Shin van der Sype. She's a PhD student and legal researcher at the Interdisciplinary Center for IT and IP Law of the KU Leuven. And during her PhD research, she's considering the limitation of data protection principles in the environmental context. And she will talk about workplace privacy in IoT. Thank you. Maybe you can.
Okay. Hello. The previous presentations, they covered several aspects of... yeah. Hello. Better? Yeah. Okay, hello. The previous presentations covered several aspects of IoT in general. This talk is about what IoT means for workplace privacy. So it's a legal discussion on the impact of IoT for the protection of personal data and privacy of employees. There will be 3 topics. The first one is about the changes that IoT will bring to the future workplaces and what the consequences are thereof. The second topic is about the legislation, the currently existing legislation on privacy and data protection in the workplace, and what are the weaknesses of this current situation. And then a short legal prognosis, like for the situation tomorrow. Okay, so IoT can be brought into the workplace by employees or by employers. And when it's introduced by the employer, there can be several goals. There can be a million goals, actually. Like for security, to increase productivity, to allow employees more flexibility in their working schedules, to regulate the energy consumption in the company, and so on. An example, the meeting room of tomorrow, there will be smart lights which are connected to sensors, movement sensors, and then we already have that when you enter the room that the light turns on. But then imagine that it's also linked to your calendar, to your agenda, and to the heating system, and then a room will not be heated unless someone booked the room. But this can then be linked to the schedule of the cleaning personnel, so then maybe they don't need to clean the room if no one was there. And also employers, the companies could decide to make a big room, to divide it in smaller rooms when it's only used by 2 or 3 people. But then IoT elements will also, like the objects will also be brought in the workplace by employees because it's just a continuous action. And this is different from bring your own device, because sometimes I hear that people say, yeah, but it's just the same as what we have with bring your own device, but the choice will be different, of course. Like imagine someone with a heart monitor, the person can't choose to just leave it at home. But if that is linked to other objects, yeah. What are the consequences of IoT in the workplace? Yeah, first of all, it will further blur the boundaries between private and professional life. This is obvious, I think. And then there will be new types and new categories of data that will be known by the employers, so things about the employees. And an example, maybe now that today employers have certain information about the health of employees, but then think of truck drivers that are monitored, maybe their face expression even is monitored to see when they get sleepy, and then their shared chair start to shake to wake them up. But of course, when you store this is a lot of sensitive information that you get about your employees. So yeah, detailed assessment, so there will be more overall pictures of employees. And this is also a bit what Brent said. Maybe it's not only about an individual, but it also says something about an individual in a group. And I think that an important element in this discussion is that in this whole scenario, the employee is not a goal of monitoring. So now when we talk about privacy in the workplace, the situation is often that employers start monitoring employees because of the employee, because they want to know what the employee is doing. But with this whole IoT thing, everything will be monitored, and the employee is just one element in the bigger picture. Yeah. So, yeah, privacy and data protection. This is a horrible slide, but that's not the point, because it's not the focus of today. Like the main thing to remember is that there is a distinction between general provisions for privacy and data protection, and then for more specific regulation for in the employment context. And on there's the more specific rules to protect employees, that is on national level. So this is different in the member states, and I will come back to this. More important are the weaknesses. I don't know whether many people understand Dutch or Flemish, but the helaasheid is really a word that grasps what is going on. There is a lot of protection in theory, but it's not really working. In general, privacy and data protection, the enforcement, it's difficult, there's weak enforcement, and also because the damages are often low, it's moral damage. You don't see it happen that often that something comes out of it. And then specifically for the employment situation, there is this subordinate relationship. And I don't know, I work for the university, and I know that sometimes they breach my privacy right? But I'm not going to sue them or something, because they're my employer. There is a really big threshold to address your employer about things like this. So when will this come up? When the relationship is already disrupted. So for example, when an employee gets fired, so a dismissal, and then it comes up that he did something wrong, and the employer finds the evidence because he monitored the employee, maybe without him knowing. And a concrete example might help here. An employee who uses a vehicle, a car of the company, and the employer installs a track and trace system in there. Then if the employee can't turn it off, that was a case recently in Belgium, and there it was said that if he can turn it off during the weekend and he can use his car during the weekends, then it's not proportionate. So the evidence that the employer was gathering there, it was actually against privacy law, but still it was used. And this brings me to my third point, that overprotection, like the very strong protection that individuals and employees specifically get from privacy and data protection law, may lead to unfair situations. And when it is brought before courts, judges will sometimes be forced to take more realistic ad hoc solutions. And this, those solutions, sometimes they become the rule. I explain this a little more with Belgian, the anti-Gewoon-doctrine. I don't know whether people are familiar with this, but it's by the case law developed mechanism to assess the admissibility of illegally obtained evidence. So, and we are talking about privacy and data protection breaches. So it can be that evidence is illegally obtained because of a breach of privacy and data protection, But what happened since 2004, okay, this was a criminal case, but it moved and now it's also accepted for employment cases. But what changed is that even though the evidence is illegally obtained, so even when it's obtained with a breach of privacy and data protection law, it will still be admissible. So unless, and then there are 3 criteria, but I'm not going to read them, but the main point is that privacy and data protection law is actually put aside, like outweighed by procedural rights, like by procedures developed by the court. This is a strong weakness. So short. Yeah. First, a simple sum. So we had the consequences of IoT for the future workplace, so the blurring of the boundaries between private and professional life, etc. And then the weaknesses that I just explained. So this will lead, I think, to a pretty messy workplace privacy future. So then the question is, what can we do about it? So not we, but policymakers. There are several options. Of course, we can do nothing and just apply the existing law as how it is. Or we can add new specifications. I had this long list of collective bargaining agreements that we have in Belgium on national level, and we can add a few that are more specified to IoT, but of course this will also not help. And then we can rethink the fundamentals of privacy and data protection, and this also aligns with what Brent said, I think. And this is not in conflict with the GDPR, because I am talking here about workplace privacy and data protection, and there is Article 82, which allows for some specifications, and I think that we can't forget how specific this situation is, and given that the GDPR is mainly focused on the protection of users, like the data of users, here this is completely different, and what we learned from Antion is that that we need, like for efficient protection, less is more. That if it's not possible for companies to comply with all the rules, if they are too strict, that the courts will come up with backdoors and to escape privacy and data protection, and in the end, the situation is worse for employees. So that's it.
Well, thank you very much, young Shin. I think we had a really interesting and great presentation so far. So take this time now to open the floor to the audience for the discussion. If
and
you have
we have 15
questions.
minutes, so
15
please.
Minutes.
Antonio Kung from Trilogue. I'm working on standardization, and I have a paper actually on the IoT, which I'll present later. My question is about standardization. So Patricia made a very good presentation on, let's say, landscape of standards for the IoT. And the problem I see, and I like her reflection about that, is actually the integration of security and privacy, actually the integration of security and privacy standards into IoT is going to be transversal. It is a huge issue. I was part of a, so okay, that's the question.
Command and questions. So how you can integrate.
The question was how to take it on. So I'm not sure to catch correctly the question. So.
Say it again.
So we have a landscape of standards. I think it's ongoing, so you can see it's complex, but it's working well, and Patricia made a presentation. But when it comes to security and privacy, we need to add standards related to that, how we deal with that. And it's not going to be a good issue to solve because it's fully transversal. So I can say, to be provocative, all the standards will be impacted. How do we deal with that?
Yes, thank you. Yes, it's really part of what I showed. You have considering the IoT, an IoT system, you have several levels, and of course the level where the security is the weakest will be the painful point. So today, for example, in 1M2M standard, we consider the security aspects at the applicative layer. That means that it's up to the service provider, to the solution provider, to choose the good connectivity which is secured enough, which takes into account the privacy aspects in terms of implementing access rights to access the data. That means that it may need also some encryptions, not to be accessed by a false actor. So it's a wide question because you have to consider the very many levels of all an IoT system. So, for example, again in 1M, 2M, it leverages, for example, when you base your system on a cellular network, cellular connectivity network, then it can leverage the SIM card, for example, where you have a trusted environment, and it's very helpful to begin with. But you have to handle also other IoT systems where, for example, for smart home applications, you don't have a SIM card in every small device, of course, and there you have to handle with short-range connectivity technologies. For example, Zigbee, Z-Wave, Bluetooth, etc. And again, you need some secured and good privacy consideration at this level. But globally, for end-to-end IoT applications delivery, you have this applicative part where we are working on addressing these privacy aspects, as I explained, where you store in a secured way the preferences of each user. Then this is also a first step, this 1M, 2M standard, a step to be connected to the big data world. And then you have to handle these big data issues where you need some anonymity, etc., to make the data anonymous. And whereas at the service layer level, you may need some very particular personal data to adapt the behavior of the system to the user preferences and behavior. So it's a compromise to be done there. So in standards, we are trying to provide the good tools to allow for privacy consideration, but then it's up to the implementation of the solution to make the good choices in terms of connectivity technologies, connectivity standards, service layer standards, etc.
Thanks, Patricia.
I have another question for Patricia as well. My name is Erich. I'm working on certification at Tilburg University, and I'm very interested in your effort of standardization. But my question is very simple: is it an open standard? May I have the access to this standard? And
Yes.
did you involve the authorities into this effort of standardization?
Yes, so this 1M2M standard is available. So as I said, it's, the release 1 is published since last year. So release 1 is available. Still in terms of privacy, it did not... yes, you just, you can... Yes, so I forgot to put the link to it, but via Google 1M, 2M, and you will be linked to this 1M, 2M portal where you can find directly, you have access directly, it's free standard. It's a free standard, and you have access to release 1 publication. For release 2, you have to wait a bit for final documentation that will be publicly available around August this year, and it includes security and privacy aspects, this release 2. And there was, yes, and related to certification, within 1M, 2M, we have a testing and certification group, so it's putting into place some program about that. So I know at least there are some, for example, there is the European Telecommunication Standards Institute, ETSI, which is used about certification process, and there is one delegate which is from ETSI. Directly involved, but so personally I didn't attend the sessions because we have many sessions in parallel, but I can provide you the contact there, no problem.
Green light.
It was very interesting presentations also about the legal risks of IoT. Are the panel members aware of the fact that in 2014 a standard is accepted in the CEN, so European standard on the DPA of RFIDs? So this gives it was accepted also by the industry and accepted by the European Commission, because the European Commission already in 2010 issued a communication that they were very afraid about the privacy risks of the use of RFIDs and sensors, and therefore they stimulated very strongly that at least a risk assessment was developed, and this risk assessment has become a standard, an EN standard, and probably will be promoted to ISO standard. The number of the standard is EN 16571 for the people who like that.
Yeah, we're aware of that, but we would more address the more intelligent devices than just RFIDs. So there's much more coming, and there's then much more you can do on privacy within the device as such. Thank you. I do.
Yes, I already have. Thank you very much. I'm Ivan Seke from Hungary. A different type of question to Brent about the concept of group privacy and the ethical implications you mentioned. We are members of a number of groups at the same time, which are partly overlapping. Some of them are quite stable, others are dynamic, with disruption, and so on, full of weak and strong connections between the members of the groups. Is it enough, in your view, to deal with the ethical consideration on a group level, or you should maybe introduce in the future a kind of multi-group privacy, because maybe you cannot really solve ethical problems in a group level, especially in the Internet of Things environment.
I suppose I would imagine what I'm talking about as that sort of concept, as a multi-group concept of privacy. And I say that because group privacy, I would say, has only started to be talked about in the past 5-10 years or so. When it was talked about before then, it was mainly talked about in relation to groups of people that formed on purpose, so groups that form because they have collective interests, for example. And that's not really the type of group that we're talking about, as you picked up on. We're talking more about incidental groups, groups that perhaps you have no choice whether you belong to or not, demographic groups, for example, or groups that exist for a very short period of time or are fluid. The membership requirements are very fluid, and that's what I would be thinking of when it comes to profiles. I don't actually think you'll ever be aware of all the groups that you belong to in that sense. I don't see how you could, or even how you could really act on it. So, I mean, this is a sense of group privacy in that it's to protect even groups that don't know they exist. And so it's quite different in that sense. I don't know if that would count as what you're thinking of when you say a multi-group sense of privacy, but to me it is a multi-group sense of privacy.
Any other questions?
Okay, two, no. Sorry, it works. Yeah, I didn't understand, I didn't see in your presentation an old idea was, I think, might be an interesting way to regulate the IoT about the CE marking. The CE marking is used for a long time in health and safety in Europe. And maybe it could be a solution to be able to implement some regulation in the IoT. What do you think about this kind of solution? No, nobody is aware about the CE marking process and all the new approach.
Could you please repeat your question one sentence?
Yeah, my proposal is to say there is an old policy framework in Europe used for safety and health. The name is a CE marking process, which is a new approach which has been begun in 1985. And I was wondering if it was maybe a new way or an old way to regulate the IoT like the safety and health, what we did in the last 20 years.
Yes. When you consider the other disciplines, there's a lot in environment, a lot in health, where risk assessment has been developed, and a lot we can use also for data protection. But still not sure what's usable, what's not. It's just the beginning of seeing what's possible, what's appropriate, what's not. But the methodology may be reused, and also the conceptual framework. Is it okay?
Yeah, you think the methodology could be useful, for example, because it's an assessment.
That's maybe the next way. We have some methodology, and we see what has been done on a very different framework. But maybe the health sector is the most developed at the moment, and there's also a lot of research available. We have to look into it. Thank you.
And I would add another ingredient to the complexity of our topic today, that is so far we have used the label Internet of Things, but don't forget that we'll be increasingly dealing with artificial agents. That's the reason why plus devices communicating with other devices, smart machine and the like, will increasingly be dealing with autonomous decisions by artificial agents. And maybe in this convergence, that's going to be the topic of our workshop next year. Thank you very much for your attention, and have a nice afternoon. Thanks again.